Hey guys, we are back and we are going to look at Kayla Bumpus's motion to quash the order to show cause, the hearing that's supposed to take place on the 25th of this month, and motion to recuse Judge Glanville. This was actually filed on the 14th, so this is 3 days behind, but Thugger Daily just posted it, so we're going to take a look. And if you watched my last stream on Brian Steele's motion to do wonders if Judge Glanville actually agrees to step down, which he probably won't. You heard me say I was going to go watch the NBA Finals, but last time I checked, Celtics were up by like 28 points. So you guys in the chat maybe keep me updated on that if anything significant happens. We're going to look at this motion. So let me make it bigger for you guys and let's jump in. Now this is going to be a little bit different because remember, Kayla Bumpus, in some capacity for some period of time, was representing Woody. So there might be certain things that she might not want to put in her filing. And then her angle, her grief, she was also accused by Judge Glanville of violating her ethics, violating attorney-client privilege, without Judge Glanville really looking into things. So the things she's going to argue are going to pertain to her more than, she wasn't held in contempt yet. She's not really in exactly Brian Steele's position, even though it's going to be related. Andrea, you were up so late for your time zone. This one's shorter though, to be fair. It's 19 pages, but it includes exhibits, so we'll be concise. We'll go right through it. So you can see here that it is a motion to quash the order to show cause and a motion to recuse this court. We're going to skip through this first part of the recitation of facts. We all know that there was an ex parte meeting on Monday. It was involving Kenneth Copeland trying to testify, but he didn't really want to. But we do get a little bit of extra clarification here that this ex parte meeting was not placed under seal. There was no protective order that directed the disclosure of these ex parte communications was prohibited. So, last week people were floating with the idea, well, there could have been a reason that this ex parte, it could have been a security issue. And that might be why the judge didn't walk out of it and make the prosecution tell the defense counsel right away, hey, we just had this meeting. But this kind of blows that out the water. So, no attorney-client privilege existed, clearly, as two prosecutors, investigators, a judge, a court reporter, and various court staff were all present. So there should not have been an expectation of confidentiality. The court never stated, ruled, or inferred that the meeting was meant to be confidential. Further, the content of this meeting was not secret, protected, or in any way privileged information. This footnote adds that if it was privilege, if there was any privilege, such as attorney-client or work product, the privilege would be destroyed with all the other parties present, particularly the court reporter. Meaning, it's on the record. The court reporter's there for what? It is unclear why any person present would have understood that the content of the meeting could not be shared with other attorneys of record in the case, who were also with fellow officers of the court. Later that same day, defense counsel attorney Brian Steele addressed this court to make a record of his due process concerns regarding the ex parte meeting. The content of said meeting would not just be non-confidential, but would usually be given to defense under Giglio and Brady, which we've talked about, during attorney Steele's attempt to put his due process concerns on the record. Now, this is why Kayla Bumpus is having to do this all. The court, Judge Glanville, began to focus on who leaked the meeting to the defense counsel. If you guys were paying attention last week, everyone was saying the same thing. He's not taking issue with the existence of the meeting. He's focused on finding out who spoke. The court ordered attorney Steele to provide the name of the person who divulged the existence and content of the ex parte meeting. Attorney Steele refused. A brief hearing followed, and what initially appeared to be a classic civil contempt action. Civil. The attorney could purge himself of the contempt if he provided the information to the judge. Became a criminal contempt action. The court found attorney Steele in direct criminal contempt. This court sentenced attorney Steele to the maximum time, 20 days, and we know that the Supreme Court has stepped in and issued the supersedious bond. He didn't actually have to serve the jail time, it was stayed. On June 11, 2024, this court entered a show cause order directing all individuals that were present for the ex parte conversation to show up. And they're going to quote this part. This is my favorite part of the show cause. If you guys read it with us, they mentioned attorney Bumpus and then said, and all representatives of the state and court security personnel that were in attendance. So even in the way that Judge Glanville wrote his show cause order that day, he was still focusing on Kayla Bumpus, but had to be all-encompassing. And he's ordering them to show cause why one or more of them should not be held in contempt. He's putting the burden on them to say why they shouldn't be held with criminal contempt charges. So that's an issue. For disclosing information from the ex parte conversation to members of the defense counsel. No specific names were included in the order, other than Copeland and Attorney Bumpus. Now, this court seeks to hold in contempt the person that leaked the ex parte meeting to the defense counsel. Thus, the contempt hearing will be about who informed defense counsel, whether to find that person guilty of criminal contempt, and if contempt is found, the appropriate punishment. The procedures that a trial court must follow to hold a person in contempt depends on whether, and guys, we're going to get with the direct and indirect contempt, which we heard Ashley Merchant go into a little bit, and the difference would involve whether the judge would have discretion. An alleged contumacious act may only be said to have occurred in the presence of the court, warranting summary contempt proceedings, if the act was committed in open court. On the other hand, where the alleged contumacious acts are committed outside of the court's presence, the considerations justifying expedited procedures do not pertain. Thus, summary adjudication of indirect contempts is prohibited, and due process requires that a person who is tried for indirect criminal contempt is entitled to more normal adversary procedures. Among other things, he or she must be advised of charges, have a reasonable opportunity to respond to them, and be permitted the assistance of counsel and the right to call witnesses. Now, we're talking about the difference being the court's presence. The court is the judge is the court. At this issue at hand, was the judge present? In Adams, the disclosing information from the ex parte conversation to members of defense counsel occurred, not in open court or in chambers, but at the time and location that defense counsel were notified of the ex parte meeting. Further, direct contempt involves contemptuous conduct in the presence of the court, which generally results in immediate punishment. Here, the need for punishment is clearly not immediate, as demonstrated by the show cause order being set 2 weeks out, and that's underscored from the order. Forms of contempt are further divided into criminal and civil, and we've all been talking about, Judge Glanville's getting schooled a little bit on the difference in open court there, based on the nature of the punishment imposed. Civil contempt is a conditional punishment intended to coerce the contemptor to comply with the court order. By contrast, criminal contempt imposes unconditional punishment for prior contempt to preserve the court's authority and to punish disobedience of its orders. The contempt alleged by this court of disclosing information from the ex parte conversation to members of the defense counsel could only be criminal contempt. Nothing can be done to purge or undo that alleged contemptuous act, and any punishment would amount to criminal contempt. And now, so because that has to be the element for this to be her to show cause in order to avoid criminal contempt, that has to be an element. And the argument here is that no contemptuous conduct occurred at all. There neither is nor was anything preventing the disclosure of this ex parte meeting to defense counsel. Disclosure did not violate a court order, because we heard at the beginning, it wasn't under seal, there was no protective order. There is no standing order in place or trial order that bars or in any way limits defense counsel for witness or any other individuals present at the ex parte meeting from communicating with defense counsel for the defendants about the meeting and its contents. Now we're going to read this footnote, because that's going to be good. But this part's important too. There was nothing barring anybody from disclosing what happened in this ex parte meeting to any of the other parties, to the defense counsel, to any of the defense attorneys. And it can and should be argued that the prosecution had the duty under Brady and Giglio to disclose some of the things that occurred in this meeting to the defense. And they didn't, even though nothing was barring it. They still didn't do it. So Kayla Bumpus, who doesn't have the stature, the same duty that the prosecution should to disclose certain things that happened in and around this meeting, she's the one that's actually coming forward, and it seems like she's in the hot seat for doing so. So we're going to read this footnote because this is going to be broken down further. Even if a protective order were in place that barred participants in the ex parte meeting with a sworn key witness from notifying defense counsel. Such an order would deprive the defendants of their due process rights. Ex parte communications are presumed to have been in error. Uniform Superior Court Rule, we talked about Rule 401 with Brian Steele's motion, provides that except as authorized by law or by rule, judges shall neither initiate, judges shouldn't initiate, nor consider ex parte communications by interested parties or their attorneys. They shouldn't be involved. Ex parte hearings are only authorized when, in the case of extraordinary matters such as temporary restraining orders and temporary injunctions. In other judicial hearings, both parties should be notified of the hearing. So they should be notified. And on the flip side of that, in the same vein, someone notifying them perhaps should not be threatened with criminal contempt. So, in other judicial hearings, both parties should be notified of the hearing with an opportunity of attending and voicing any objection that may be properly registered. These general requirements repeat in the Georgia Code of Judicial Conduct, and this is going to be similar language here, so we're not going to double down. To the extent that this show cause order may be subject to a general demur, the order cannot pass that test. Now, footnote 5 here cites Jackson v. State and mentions that to withstand a general demur, an indictment must recite the language of the statute that sets out all the elements of the offense charged, or 2, allege that the facts necessary to establish violation of criminal statute. If either of these requisites is met, then the accused cannot admit the allegations of the indictment and yet be not guilty of the crime charged. So what are they going to go on to argue here? Assuming as true that the allegation in quotes, of, quote, disclosing information from the ex parte conversation to members of the defense counsel, contemptuous conduct is not alleged. So they're saying there's a fatal flaw in this show cause order. They're missing the very things that would need to be established. And we looked through that show cause order. I think it was less than 2 pages. It was like, there's a big header on the first page of any court filing where it lists who this is against and the court name and the date. So you have like 3/4, maybe half of a page, and then it was about half of a page on the second page. It wasn't a very long order. So it makes sense that they missed some of the critical pieces. Furthermore, contempt may only be found where the attorney knows or reasonably should be aware in view of all the circumstances, especially the heat of controversy, that he is exceeding the outermost limits of his proper role and hindering rather than facilitating the search for truth. So they cite Jefferson again. Disclosure of the meeting did not exceed the limits of anyone's proper role, and if anything, the disclosure facilitated the search for truth. A judge may reasonably expect his clerks and other judges to keep what happens in chambers professionally private. However, they're still under no legal duty to do so. So this means that expectation might be there just because, as an informality. But if it had been the transcriptionist, Kristen Weaver, if she said, hey, I don't like what they did to Woody, this doesn't seem right, it wouldn't have been against her legal duty. There was no legal duty binding her to be confidential. Such an expectation of privacy does not extend to third parties not part of the court staff. Holding an ex parte meeting in chambers did not impose a duty of secrecy. Informing counsel for defense of the existence and content of this chambers meeting did not violate any rule of law, trial order, or standing order, and is not a basis for contempt. Now I'm going to ask you guys in the chat, if it was the case that this disclosing something like this, maybe not even this specific circumstance, but in general, something like this, something similar to this, if it was barred, if disclosure of this sort of thing was barred, do you think this would be used all the time, more often than it might already be? And on the flip side, for the defense, the opposing party here that's not part of these meetings, how could they know that they'd ever get a fair trial if these things were permissible, if this confidentiality was always guaranteed and people that were present were barred from talking about what happened during these types of ex parte meetings? There couldn't be justice. There really couldn't be justice. Because there'd be all these inner dealings, and there's an issue already of inner dealings that we're not aware of. But if inner dealings were permissible and allowed and commonplace, how much worse would that be? So the show cause order, failing to articulate an act of contempt, should be quashed. And this court must transfer this contempt matter to another judge. So now we're getting into a second arm of the argument here, that it shouldn't be Judge Glanville making the decision here, because that's the procedure for indirect contempt, or alternatively, the court, Judge Glanville, should recuse himself pursuant to Georgia Code of Judicial Conduct, Rule 211. This court must transfer this matter to another judge under the procedure for indirect contempt. And they're probably citing here, seeing the accompanying affidavit, which asserts facts upon which this motion is founded. So in this affidavit, we're probably going to see points that establish that the judge was present at this meeting, and thus he should be considered a witness to everything that's going on, and thus he can't make a, he can't be the one to hear this thing about himself that he was a witness to. So in indirect contempt actions, the trial judge who was presiding over the trial during which the alleged contumacious conduct occurred may preside over the contempt hearing if the contumacious conduct was not directed toward the judge and the judge did not react to the contumacious conduct in such a manner as to become involved. He was right in the heart of it. Here, the alleged contemptuous conduct, as expressed by the court, and they're going to call it sacrosanct. So we kind of know this part, guys. We're going to move a little bit forward. They're going to cite the code again. But here we know the same thing. We're going into is the judge credible? The judge was a witness. It's not reasonable for him to make this decision here. So, and then let's actually read this quote, because this is actually important. So another point they make, this court appears to already have decided. So this is something new that we didn't really get in Steele's motion or Ashley Merchant's motion. This court appears to already have decided, prior to any hearing, that it was Attorney Bumpus who made the disclosure. While holding Attorney Steele in contempt, this court had stated, well then, other than if you, Attorney Steele, if you were sitting, unless you were sitting in there with a recorder, or Miss Love or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left. And if that person gave you that information or shared that information with you, and this next sentence is the problem, she probably violated privilege. So he was refusing. Brian Steele wanted to hold a hearing. He wanted someone, not this judge specifically, but Ashley Merchant was in there saying, like, look, you've got to have a hearing and you shouldn't be the one presiding over it to really find out what happened. You can't preside over this because you are a witness to it. But instead, the judge refused. He said, I'm going to hold Brian Steele in contempt. And it was probably Kayla that did it. And in doing so, she probably violated privilege. That's bordering on disparagement of this Attorney Bumpus. So that's why this grievance is a little bit different than Brian Steele's, because, that wasn't levied against Brian Steele. This is Kayla Bumpus's unique grievance against Judge Glanville. The court's show cause order reinforces this predetermination as the order references no other person present at the meeting by name other than Bumpus or Copeland. Fifth and finally, the court was visibly impacted when it learned that Attorney Steele had been informed of the meeting. And I agree, right? You could see, if you go and rewatch Monday, you can see when Brian Steele's like, I have an inquiry for the court. You can see the demeanor change. You can see Chief Deputy Love, she's like all jerking her head around. As soon as this was brought to the attention of the open court, everything shifted. The Georgia Supreme Court referenced an opinion echoing this case and noting when a recusal motion clearly has merit. But what if the motion to recuse has merit? What if the judge who announced an oral ruling, or reasonably appears to be partial or prejudiced, and therefore has no business continuing to preside over the case? So they cite Rule 211 here. What if, for example, a party defending himself at a contempt hearing turns around and accuses the judge of prejudice, and the judge actively defends himself and then orally holds the accusing party in contempt? So they're explaining that argument over recusal issues may draw the judge in presenting his side of the story, which in turn may create a perception that the judge is an advocate or a hostile witness rather than an impartial adjudicator in the case. Which is why, if he's a witness to all the stuff that's going on, he can't be the one making the decision over it. This alleged contempt is not ongoing and does not require immediate resolution. This court has ample time to transfer this case to another judge who is not involved in this ex parte proceeding, who is not a potential witness to a potentially disputed evidentiary fact, who does not view the harm to be, at least in part, a direct harm to the judge personally and or the sanctity of that judge's own chambers, and who is not called to determine whether that court's own security personnel or reporter committed the alleged contempt, and if so, what punishment to impose. Now, this was a long sentence, but it covered a lot of pieces, right? They're saying that even just the smallest bit of a loyalty to his own staff, remove all these other parts. Even if it was just an issue of, well, if it's either me or your beloved court reporter, or me or your beloved deputy, it's already going to be difficult just with that context alone for the judge to not be partial. So he shouldn't be the one making the decision over this. So really, really good long sentence there. This court must provide notice that fairly and fully informs the accused of the specific acts of contempt. Now, this was pointed out. Someone left a comment. They're like, oh my God, this order to show cause. It's not even saying what they'll be holding contempt for in the last paragraph. When a contempt proceeding is criminal, the full panoply of constitutional protections must be afforded to the accused. This includes a notice fairly and fully informing the accused of the specific acts of contempt. This requirement of reasonable notice in a case involving an alleged indirect contempt contemplates and necessitates a written notice fairly and fully informing the accused of the specific acts of contempt with which she is charged, and so given as to afford a reasonable time to make her defense. Now, what's the problem here with what Judge Glanville wrote? He wrote this order to show cause or face criminal contempt, but the order was really geared at getting people to show up on June 25th for this hearing, or to tell him before that meeting. But he didn't really lay out what was the issue, what was violated by them. Any notice short of that would make a hollow mockery of the fundamental and abiding truth that reasonable notice to one whose civil rights or personal liberty may be affected is a veritable cornerstone of our judicial system, and that would constitute nothing more than an exquisite exercise in frustrating futility. That whoever wrote this case law, this decision, they're using a lot of alliteration here. We got exquisite exercise, frustrating futility, sometimes misleading and always meaningless, and would be but sounding brass and tinkling cymbal, a notice in form but not in substance. Yeah, this person must have been like an English major. whoever wrote this decision in this case that they're citing here. So that was in Harris. Like all crimes, contempt has an act requirement and a mental component, so mens rea. The notice alleges an actius reus, but fails to put Attorney Bumpus on notice of the mens rea. So, cool, we know that the meeting was disclosed. But how would the discloser know that such an act amounted to contempt? Because there was no protective order. Because there's nothing statutorily that would prevent this disclosure. She's not a staff member that has a broad, overarching expectation of confidentiality. There are multiple parties present that would void any expectation of attorney-client privilege. So without any of those things, where's mens rea? And then worse, the show cause notice that Judge Glanville wrote and filed does not allege facts from which contemptuous mens rea could be inferred. So he doesn't lay it out in his order to show cause to show up for this meeting on June 25th. As set forth above, the act of disclosing the meeting to defense counsel cannot, in and of itself, amount to contempt. The disclosure could only potentially amount to contempt if it violated a court order or some other legal duty to not disclose the ex parte meeting. The notice fails to allege any such restriction. So as such, the notice fails to fairly and fully inform the accused of the specific acts of contempt. Now again, this is a criminal contempt. She and all the parties are at risk, according to this order, for being thrown in jail if they don't abide by whatever the show cause order is asking for. So the burden's not really on them to show, hey, let me go search and figure out what I violated, and then let me prove that I didn't do it. The burden's on Judge Glanville. What actually was done wrong? And what are the facts to support that? Wherefore, Attorney Bumpus moves this court to quash that order to show cause, and if not, in the alternative, recuse itself from this proceeding and or transfer this proceeding to another judge whose impartiality can't reasonably be questioned, or in the alternative of that, provide an adequate notice that fully and fairly informs Attorney Bumpus of the alleged contempt. And then should all of the above requested relief be denied, Attorney Bumpus requests a certificate of immediate review, so she can get an appeal right away. So she submitted this again. This was on the 14th. And then, where was the affidavit? Oh, and I was over. The order to show cause was 3/4 of a page. It all fit on one page. So I overestimated how long it was. But this second paragraph here, it was pointed out to me. This is where the contempt is threatened. Let's see if you catch the missing words. It is further ordered that the failure of any of the individuals who were present for the June 10th, 2024 ex parte conversation will cause the court to direct the Fulton County Sheriff's Office to take them into custody and bring them to the bar of this court. The failure of any of the individuals, usually right here in between these two words, you would expect to do X, Y, Z. The failure of any individuals who were present for the June 10th ex parte conversation, the failure in general, arbitrarily, not fully described here, will cause the court to direct the Fulton County Sheriff's Office to take them into custody. This is a mistake. This was a rushed filing. It's missing. Kayla Bumpus is 100% right to point out that this is not fully written out and described. And if it's not fully written out, how can you properly defend yourself against what's being levied against you? So Judge Glanville, remember this came out at 3:14. I think we were pointing that out. He had taken a recess around this time, like an hour-long recess. And then this got filed at like 3:14 p.m. And a lot of us were like, oh, he like ran and rushed to file the show cause order. So sure seems like he rushed through it. But let's look at this affidavit here. Some of it's going to be a bit repetitive, a bit cumulative. But it's a different way to write it. We're going to see what it says. So personally, appeared before the undersigned officer duly authorized to administer oaths, Julian Collins, Kristen Nove, Gabe Banks, Nicole Mormon, and Matthew K. Winchester, who, upon being duly sworn, depose and state the following under oath and penalty of perjury. Now, these are all the parties that just helped file this motion on Kayla Bumpus's behalf. So you've got your Julius, you've got Kristen, you've got John. I don't think John was just mentioned there, was he? But that's essentially who's swearing on this affidavit. Yeah, I don't see Joseph mentioned here, so he helped write this filing, but he didn't sign the affidavit. Chief Judge Glanville is presiding over the above-styled case. Sworn witness Kenneth Copeland was held in civil contempt on Friday, June 7th for refusing to testify after being given a grant of immunity by Glanville. On June 7th, Judge Glanville informed Mr. Copeland and all parties that Mr. Copeland would be jailed and brought back to court on June 10th at 8:30 a.m. On that morning, Monday, June 10th, an ex parte meeting was held in Chief Judge Earl Glanville's chambers. That ex parte meeting included Judge Glanville, Mr. Kenneth Copeland, his attorney Kayla Bumpus, and representatives of the state and court security personnel. Later, Mr. Steele, counsel for Mr. Williams, informed Glanville that he and others had learned of that ex parte meeting. The court acknowledged that this meeting had occurred. Mr. Steele requested information about the ex parte meeting, which Chief Judge Glanville did not provide. Mr. Steele made a motion for a mistrial, asserting that the ex parte meeting violated Mr. Williams' constitutional and statutory rights, including the right to due process and a fair trial. Judge Glanville denied Mr. Steele's motion. And that's separate. That was earlier than what we just read today. The newly filed today motion for a mistrial, motion to recuse from Brian Steele. So this is talking about the oral argument in court that day, that Monday. Chief Judge Glanville repeatedly ordered Mr. Steele to provide the name of the person who divulged the existence and content of the meeting. Mr. Steele, citing State of Georgia Bar Rule 1-6, confidentiality of information, declined to provide the information requested by Judge Glanville. Chief Judge Glanville held Mr. Steele in contempt for refusing to provide the name of the person that divulged. The next day, on June 11th, Glanville entered a show cause order directing, quote, all individuals that were present for the ex parte conversation that took place in the court's chambers on the morning of June 10th to include Mr. Kenneth Copeland, his attorney Ms. Kayla Bumpus, and all representatives of the state and court security personnel that were in attendance, to show cause why one or more of them should not be held in contempt for disclosing information from the ex parte conversation to members of defense counsel. The order to show cause only references Attorney Bumpus and Mr. Copeland by name. All others in attendance, despite having access to the same information, were not named in the order. Upon learning that Mr. Steele was aware of the ex parte meeting, Chief Judge Glanville stated, quote, "This is so sacrosanct to have a conversation in my chambers, parroted to you and others. It is that serious." So yeah, something that should, at least in part, have been disclosed to the defense. When Judge Glanville finds out that some disclosure was made, he's calling it parroting. During his exchange with Mr. Steele on June 10th regarding the ex parte meeting, Chief Judge Glanville said, "Well then, if none other than you," and we read this earlier, but we're going to read it again, and Miss Hilton's name is spelled right here, "if you were sitting, unless you were sitting in there with a recorder, or Miss Love, or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left. And if that person gave you that information, or shared that information with you, she probably violated privilege, because she has a client she's supposed to represent." The she that Judge Glanville was referencing in the statement in paragraph 13 was Attorney Bumpus. Chief Judge Glanville made the statement's reference in paragraph 13 before he made any inquiry or factual determinations. Chief Judge Glanville has already determined, without this inquiry, that it was Bumpus that leaked the information, and leaked is in quotes, to Mr. Steele, and that determination was made prior to any hearing, and based on his own knowledge and belief. Chief Judge Glanville accused Attorney Bumpus of violating attorney-client privilege. That's not a good thing to be accused of. That's not an accusation to levy and launch at somebody lightly. But Glanville did it to Attorney Bumpus. Accused her of violating something that's paramount for a defense attorney to maintain, attorney-client privilege. So, by speaking to Mr. Steele, Glanville says that Kayla Bumpus violated this super, sanctimonial thing. And he made that accusation prior to any investigation, hearing, or reviewing any evidence. Chief Judge Glanville intends to preside over the June 11th, 2024 order to show cause. Maybe this is supposed to say 25th in the same above-styled case, and he will be the fact finder and make credibility determinations concerning the parties present at the ex parte meeting. If Glanville were to preside over the show cause hearing, he will have to make credibility determinations of the court's own security personnel, which would make him, he might be partial to the people he works with day in and day out. So Julius, Kristen, Gabe, Nicole, and Matthew all signed this. So just like we've seen these affidavits with Steele and with Douglas Weinstein, where they're writing what was said, Kayla's attorneys are writing this affidavit. It's not Kayla herself signing these things. And what are we missing here? There's one thing that we're missing here. That the other affidavits, well, I don't remember if Steele's did, but Weinstein certainly did. And Steele brought it up on the floor on Monday. But what are we missing from the affidavit filed really on Kayla's behalf to help substantiate this motion to quash the show order, show cause, and this motion to recuse from Kayla? We don't have a fact laid out here about things her client may have said or how her client may have acted. Probably appropriately so, she leaves that stuff out. And that could be good for her client. You know, Woody probably, if Woody was firing her, Woody probably didn't say, "Yeah, you know what, go ahead, I gave you permission to talk about all those things." Probably don't have permission there. But still, since that was in some capacity, she was representing him even for that one day. She doesn't come into this affidavit and tell her attorneys that are writing this, like, hey, this, they don't include this in this filing. She's leaving certain things out that protect what would have been her client for that time period. But what are you guys saying? So that's the end of our motion there. And I know for, some people, Don't want to go through all the chit chat. We'll get through the motion, and I got to work backwards and check what you guys are saying in the chat. And then, hey, Michael Sanchez, good to see you. Rumpus? Was that a typo, or did you type it as rumpus on purpose? Oh, and then Andre Jones, shout out. Okay, so you sent the motion to Thugger Daily. I got it from Thugger Daily, so like 2 degrees of separation, I really got it from you. So shout out to you. Everyone say thanks to Andre in the chat. And then Rubber Toe says, I gotta believe that by the 25th, this judge is finally gonna be feeling the heat enough that he's somehow gonna backtrack his mass contempt thing, if for nothing but self-preservation. I mean, you would want to see that, right? Like, hopefully, maybe, like, something's gotta give. Someone has to be messaging Glanville, like, bro, what are you doing? Like, chill out, let it go, bail. And then, oh my gosh, Dre, it's 3:11. I mean, I used to be a night owl. Maybe you're a night owl and you can do that. By, like, the time it hits 2 a.m., I'm, like, over my second wind already. So I appreciate you for being here, Drea. I have a message I gotta go and look that you sent me on X or Twitter. And heck yeah, so Rubber Toe says you love that the judge keeps stepping in it, right? So you would think he should, like, get it together, maybe step back from it, have some humility, right? Put his ego aside, maybe it's ego. I don't know. But at the same time, because it keeps going, there's just so much more to look at for like us, for our sake. We're like, well, what's coming out today? What's being said now? Is there any more that Judge Glanville did? And I think it was important that we got that detail spelled out, that there was no protective order in place. Nobody at the meeting was told or instructed, hey, you have to hold all of this in confidence. I mean, we kind of speculated about that, but it's nice to see someone who was actually present during that tell her counsel, who was now writing this affidavit, there was no protective order in place, and we weren't told we couldn't disclose this stuff. So nothing's barring us from disclosing it. I thought that was a really important thing to have it actually laid out. And then you're watching the madness too, Silent Sniper. Hey, High Value Man's in the chat. Although I think we can't call you. I saw another HVM in TLA's chat today. So we're going to have to go with Marcelechka. We're going to have to say it all the way out. And if I'm saying it wrong, you got to correct me. But it's always good to see you. And then Jess, good to see you. Jess says, wow, the judge would have to recuse now. Who thinks he will? I don't think... Does anybody think that he will? Does anybody think that he will? Demetia, this is important too, and you can't say it enough, that if this is happening in this televised trial with all these eyes on it, with all these YouTubers and all the people in the chat talking about the details, right? This is not some case that's, under the radar, off the grid. You say, I can only guess what they've been doing to others in that courtroom. And similar courtrooms, right? This probably isn't isolated to just one, but, I'm never tired of hearing this pointed out. I think we got to keep pointing it out. What goes on if this can take place? And in Brian Steele's motion, we have the question levied. Hey, were there any other ex parte parties, secret meetings that we should know about, similar to this, that we only found out because someone told us? You guys didn't tell us. Was there more than just this one instance? It's a great question. And then let's see. I see you guys having a lot of conversations between yourselves in the chat, and I really love to see that. Carol, I was thinking that too, that Miss Weaver will look out for Woody too. It's really been kind of cool to see. He's a witness in this party. He's not even a defendant, but technically he's at risk for being accused of certain things. I know he has the use immunity, which protects him from state prosecution, but he's not really in the clear from all prosecution ever. And we've heard that the cops apparently have arrested him for stuff he didn't do before, or they tried to rearrest him and hold him without charging him with something new. I mean, I'm sure that they'll be out for blood against Woody. That's in addition to any other risk that, any target he's got on his back for being a witness in this trial. And we still haven't heard anything about a security issue being the reason this ex parte meeting had to be secret. Nobody instructed it to be secret. But I do think it's really nice that the court transcriber, she's treating a witness like the human that they are. And then Rubber Toe says, I'd last a week at that job if I was legally prevented from reporting in serious shenanigans. Although, to be fair, if she did a good job with the transcripts, her integrity would be there. And then, yeah, Drea, so earlier with that question, Drea saying that it's totally unfair. How would you be able to trust the system? And heck yeah, so the other cat in the chat, hey, my fellow cat, Cat says hit the like button. I promise that's not me in the chat saying to hit my like button, but I'm going to echo the other cat and say hit the like button. Even if you're about to wind out of here and get on out, just hit the like button on the way out. And then I'm no singer, so I'm just going to read that you hear the train a-coming, it's rolling around the bend. I've got like 2 go-to karaoke songs, and that's all I'll do because I can't really sing. Michael Sanchez, the judge should retire. Get out of the kitchen before it burns down. Like, while it's still kind of standing. Get on out. And I'm going to scroll way down. I want to say hey to Jim Kirk. You're asking, so is there any way this reasonably doesn't end in a mistrial at this point? It's too high profile to sweep under the rug. I mean, it's really got to be the decision of someone other than Judge Glanville, because I personally don't think he's going to budge. I haven't really seen anyone. A lot of people are saying he should budge, do the right thing, hand at least this order to show cause hearing, hand that over to somebody else. Hand any hearing for the contempt order against Brian Steele, hand that over to someone else. And he won't even do that. So, obviously, I don't want to say it's impossible, but it's an improbable possibility that he would say, yeah, you know what, I'm finally going to grant a mistrial. I just can't picture it. It's going to have to happen outside of his courtroom, outside of his bench. And that could take some time, but I mean, maybe the Supreme Court of Georgia, we see them moving fast for Brian Steele's behalf. Who knows? Maybe we'll get some action somewhere, someone stepping in. But I don't know. I mean, I think all eyes are on this watching. Because it's still unique to watch, right? It's not the first time a mistrial or like a conflict of interest or something like that would happen. But I think this is really... Does anyone know of any other examples of something at this scale? Mid-trial? Like, it's like a RICO trial, we have all these co-defendants, and it's a state RICO trial, it's not even the feds prosecuting the RICO. So that's novel in and of itself in a way. And then you've got all of this mess going on. Have you guys ever seen a witness like Woody? like, I know witnesses can be goofy sometimes, but there's just so much here that I think it's like a unique situation. I don't think there's really a roadmap. We know what should be done, or what shouldn't continue to be allowed. But what's the remedy to make that happen quickly? And will it happen? And then Rubber Toe, I'm glad that Kayla got herself a good attorney to write that petition. She seemed kind of deer in the headlights at the time. And it sucks because I'm not one to use the term gaslighting easily. But I do wonder, did she feel like, because Judge Glanville was making it seem like she violated attorney-client privilege, maybe she started to believe that and question that because he was saying it. You're an attorney, he's a judge, he's had decades of experience in this position, and he's telling you that you probably violated attorney-client privilege. I think that would give me pause. Even if I'd read all the rules and said there's no way. Someone in that position telling me that, it would give me pause and I'd be like, oh my God, what if I did? And it would have had my heart racing the whole day. Like, and then it's on TV, everyone's going to hear about it, and I possibly did like the worst thing you can do to your client as a criminal defense attorney. Well, she's not a criminal defense attorney by practice. I think she does like personal injury. So that's an extra layer for her too, right? Maybe she was questioning because it's not her normal area of practice. And then the judge is like, oh, you probably messed up. So I'm definitely glad that she got an attorney. I understand why she may have come off as a deer in headlights, especially since we were all watching. I mean, there were like 10,000 people watching the stream I was in when she was standing up there like, I don't want to say it in open court. So, just crazy stuff all around. Tariq, exactly, this is crazy. And then, let's see. And then Angela and Eric, I think, so I don't know if I'm speaking to Angela or Eric, but hey to you both. Every attorney in the district should paper or notice the courts that they refuse to practice in front of Judge Glanville. Well, can you imagine all the motions to switch judges for any pending case now? So they're all going to be, nobody's going to want to be in front of Judge Glanville. Or maybe they will, because they think it could be a pathway to an appeal issue, right? An easy appeal issue. But what's that saying, that appeals are for losers? But, maybe it could be strategic. And then I'm going to scroll through. So I do apologize if I'm missing everybody. I want to say hey to Christine Williams. And you think that Judge Glanville is a veteran military man and he's used to having his way, but the ego is going to get to him this time. I'm hoping it's his ego and not greed. Right, and that is a little bit different, right? Greed is a bit more malicious, where ego could just be ignorant, lacking self-awareness. So there's a pretty big difference between ego and greed, and that's a really apt distinction to make. I like that. And then Lone Wolf, we need to remember the jury is the ultimate law and start making them really prove their case beyond a shadow of a doubt. Well, and then can you imagine being a jury in like a 2-year trial where there's all these faces and names and dates to keep track of across over 10 years of time? A question I have for myself is, what if the jury is stuck and leaning to say, well, something must have happened because there's 2 years worth of trial here. So surely someone must be guilty of something. And it's so confusing to us that we're going to choose to just pick some of these charges to stick. Like, how can you expect a jury to really track everything that's going on for 2 years' time when they're making like $25 to $50 a day if you include stipends for food? Like, it's a big question. And then a shout out to Isaiah Harris, says Glanville is so involved in this case, he's drowning himself in corruption. Still time to get up out of there, but who knows if he will. Andrea, or maybe it's Andrea, says Fulton County is an SNL sketch. I mean, can you imagine, guys, if they gave Woody, like, you know how they bring on like a guest host for SNL? Just bring Woody up there. He'll make people laugh. They'd probably get great ratings. Shout out to Ali Garcia. Hey. And then, yeah, so Sia Human, good to see you. Smash the like button. Mash, we not doing that here. We not doing that here. And then Dan says, as a judge, this is despicable. But also in general, as a general in the reserves, I would claim conduct unbecoming an officer. I mean, maybe there's something going on. I know people have pointed out to me that he has a support dog with him. Like, maybe there's just something switching. Something going on. And just because something's going on isn't an excuse for it to just, roam free and impact someone's right, multiple people's right to a fair trial. But maybe there's something going on that we could understand if we're able to know about it. And it wouldn't just be this shocking, blatant, doing things wrong because we don't care type of explanation. I always like to find out a reason, have some closure, and I hope we get something beyond just, he just went rogue and said, forget it, who cares? I don't want that to be the outcome. I don't want to miss you guys. I'm not used to having so many people in the chat, but it is a lot of fun. And Tony, yes. So Tony Palmer says that I found out today that she was just filling in for that day while his attorney was out of town, and she's actually an injury attorney, not a criminal defense attorney, right? So I think that goes a lot to why she may have seemed a little bit shy. We're used to, we were like, oh, Brian Steele's running up to argue with the judge. He's running up to the podium. It's different. Kayla got up there, she was waiting to be addressed first, and she said, well, I don't really want to speak it into open court. I think that's a big explanation why it's, criminal defense is not really her wheelhouse. She was thrown into it. I don't hold it against her for being a little bit shy. And then Silent Sniper says, Woody is show by himself. He has a lot of important things to say soon. I mean, Cross will probably be insane. Cross will probably be insane. Ghost King, great point. That this is a trophy case because it opens the door for Rico to be tried and killed. Tried like every other regular criminal charge. So I think that's a problem too, and you're kind of seeing Georgia trying to pilot test this stuff. They've got multiple RICOs going on. I think, was it YFN Lucci, but he pled out. But that was part of some RICO charge. You had the school testing, the school cheating. That was also RICO, wasn't it? You've got the Trump case, which is still active. And then you've got this one. And it's just kind of like, all of this money, all of this time is being spent on prosecuting really a small group of people. Then you've got data from the ACLU that's showing of these, people that are sitting in jail for more than 90 days without a bond hearing, without charges. There's no indictment against them. Statistically, they're overwhelmingly Black and Hispanic, or they're just in a lower class. They can't afford a basic bond, so they need this bond hearing. They're not getting it. Nobody's charging them with anything. They're sitting in jail for a long enough time period that if they are employed, their employer's probably like, well, what gives? You haven't shown up for work. You're dismissed. We assume that you abandoned your job, or we're going to fire you because you're just not here. And then even if the DA finally says, all right, well, we're finally looking at your case. We don't really even want to charge you. We're going to put you through a pre-indictment diversion program. Well, you've just spent 90 plus days locked up for nothing to go back to your life where you haven't been making paychecks. You've been separated from your family and or kids if you have kids. Like, how is that good for a community? How's that good for neighborhoods? How's that good for, personal development? You get out and you're denied the ability to work for 90 or more days. There's people that live paycheck to paycheck. Imagine 90 days, that's multiple payrolls that you're depriving someone of. All without any charges or indictments. So it's worse than just the RICOs. I think there's a problem in Fulton County specifically, but probably elsewhere, with just these bad charges. Slow, backlogged prosecutions. Prosecutions looking for these big targets. High-profile cases, celebrity cases. Things that look like, I'm a DA and I can get reelected if I'm the one that finally gets this person locked up. And then you spend all these resources doing it. But what impact does it really have on the community? I don't think you can tell me it's a positive impact all around. So your point, very, very well taken. And then, hold on, who's talking about if Woody became sheriff? What are you guys doing in the chat? Sheriff Woody. Oh my gosh. That's too funny. Transplanted Texan. Good to see you in my neck of the woods. Shout out to Transplanted Texan. And then, yeah, actually I noticed that too. So Drea's saying that a YouTuber in court, infamous Sylvia, has reported that the jury most days looks checked out. I mean, can you blame them? Can you blame them? Yeah, so we don't do that here. And then, Dear Old Christian, good to see you. You and Transplanted Texan. So good to see you. Dear Old Christian, by the way, if you guys are following Fulton County and you notice that Fani Willis just did a church speech, I think it was like Friday, maybe? My days are all messed up. But Dear Old Christian was there, recorded it, streamed it, and these news outlets only covered like one quote, two quotes here and there. If you want to go check out the full thing and any other content, let me pull up his channel right now, and I'm going to drop that in the chat. So you can go and check that out and more. Also done a lot of content talking about everything that happened in the last week with the YSL trial, which there's no shortage of things to talk about with that trial, I would say. Let me get your channel. What I need to do is I need to create like a Rolodex of channels so I can copy and paste channel links and share them easily. But there you go. That is Dear Woke Christian. I usually say DWC for short. So I just shared his channel there. So make sure you go and subscribe over there. And then, wow, I am so behind on the chats. I am never going to catch up. and then I get lost sometimes. But I love that you guys are... The speech was Thursday. I was only one day off. But I love that you guys have your own conversations in the chat. If you guys have heard me say it before, I love YouTube for the chat feature, and I'm usually at home in other people's chats. Dear Woke Christian is someone I've had a great time in live chats on his streams. you know, lead attorney. Earlier I was talking about potentially criminal Sean. I really love the chat feature on YouTube, so it's really cool to be on this side of it and see you guys having your own conversations. I love it, but I'm having a hard time keeping up. And then Jonathan Brown, shout out to Jonathan Brown, is saying his ego won't let him recuse. And then let's see, where did I see JT Moore in here? I see someone tagging JT Moore. I didn't see JT Moore say anything. I don't see the comment, but it's good to see you. It's been a while since I've seen you, JT. And then the Celtics won. Did the Celtics win? Yeah, 106-88. 4-1 taking the series. They had Brian Windhorst tried to put some wind under Luka's sails, but it wasn't enough. It was only good for one game. Oh, yeah. Good logic. Good logic. He didn't hit 100K yet? So Good Logic, and you know, Good Logic I like for his philosophical conversations. He does a lot of great news if you want to follow things like, he did a lot of coverage on the Trump case in New York. He was also filing, and I'm going to get this wrong, I don't want to butcher it, but he was filing something to go, I think he wanted to go right to the Supreme Court if possible, against the gag order. He was fighting as a member of the press and as an individual for, you know, First Amendment access, public access. In other words, this gag order that you placed on defendants like Trump is a violation of something we're supposed to hold as sacred. And he did a live stream like penning, writing it out. He's an attorney, so he was doing the writing, the legal writing. I thought that was really cool way to use YouTube. So Good Logic, spelled LAWGIC. Really interesting content there as well. Also, he's really religious, and I love listening to like the philosophical conversations. Just very, very smart, great advice that he gives out for just life, living life in with better discernment, better critical thinking, and keeping yourself 2 feet forward at all times. So shout out to Good Logic too. He's not in here or anything, but. And then what else do you guys have? Let's see. Yeah, hit the like button. So let's round this up, guys. It's always so fun to have the chat. I love you guys so much. It's so much fun. Got nothing else until there's another filing, though. So next time something comes out, shout out to Andre, who sent the filing over to Thugger Daily to bring us this stream. I appreciate you guys. You all have a good one, and see you next time, whatever that is.